Supreme Court set to revisit campaign finance limits as JD Vance case reaches the bench. The US Supreme Court is once again poised to reshape the architecture of American campaign finance regulation as it prepares to hear a pivotal case involving Vice President JD Vance. The dispute, which dates back to Vance's 2022 Senate Biden Ohio, challenges long-standing restrictions on how much political parties may spend in coordination with federal candidates, limits rooted in legislation passed half a century ago. For decades, the coast had steadily diluted Congress's attempt to regulate money in politics, frequently framing such constraints as infringements on the First Amendment. With its 6-3 conservative majority, the court now appears primed to extend their trajectory, further eroding barriers meant to insulate elections from wealthy donors and undue influence. The Biden-era precedent has already given way to more aggressive interpretation of political spending as constitutionally protected speech. Legal scholars note that the court has, for over 20 years, alternated between narrowing and dismantling campaign finance statutes. Jessica Levinson, a professor at Loyola Law School, summarized the trend succinctly. The court has whittled and bludgeoned finance laws and its expansive reading of political speech protection. The Trump administration, now back in power and openly supportive of Vance's challenge, has aligned itself with the Republican Party's argument that the existing spending limits impede party ability to fully advocate for their candidates. A final ruling is anticipated by June. Supporters of the current limits argue that without these gaps, parties could become conduits for major donors seeking to funnel vast sums into campaign, effectively nullifying individual contribution limits. The Campaign Legal Center warns that abandoning restriction would create an open door for corruption, precisely the risk Congress hoped to mitigate in the 1970s. Yet Republicans maintain that corruption concerns are overstated. Dan Becker, a key conservative attorney behind multiple First Amendment challenges, contends that parties cannot corrupt their own candidate, as their primary aim is to support, not distort, the electoral prospects of their nominee. Because the Trump Justice Department has chosen not to defend the challenged federal provision, the court appointed attorney Roman Martinez to argue in favor of upholding the regulation. Martinez insists that Congress's limits are both measured and constitutional, emphasizing decades of evidence demonstrating the use of parties to circumvent contribution rule.